Okay, why don't we get started now? Once again, I'm Michael Coviello. I am the Associate General Counsel for the National Fraternal Order Police Division of Labor Services. And if you tuned in to listen to substance abuse testing for law enforcement, you've tuned into the right place. We are going to discuss the various aspects of substance testing in general, and specifically deal with post-incident drug testing or substance testing as it applies to law enforcement officers. Before we get started, one of the things I do want to let you know is that whatever your jurisdiction's rules, regulations, policies, laws, statutes, etc. Require will take precedence over whatever we discuss here today. We're going to discuss these in very general terms. We're talking to people across a broad level of jurisdictions, and no overview could possibly contemplate all of those different rules and regulations. So before anybody decides to take any action with their employer or in response to an order to take a drug test, if you have some concerns about it, you should discuss that with counsel licensed in your state to practice law, and someone who can provide you with the best possible legal advice. So having said that, where did drug testing in the workplace come from? Well, in the beginning, there was Ronald Reagan, who signed an executive order in 1986, and here's the executive order number, and it established a drug-free federal workplace program. Now, you notice it says federal workplace. This is where the proving ground was people employed by the federal government. This has, of course, trickled down and affected every workplace of every level of government and is essentially universally applied. This executive order forms the basis for all employee drug testing, not just in federal employment, but in government employment. And Section 2 of the executive order requires that the head of each executive agency develop a plan for achieving a drug-free workplace, including identifying illegal drug users through testing. The three types of testing that we talk about for sensitive positions, and sensitive positions includes law enforcement officers, is when there's a reasonable suspicion or indicia that an employee is using illegal drugs, in an examination authorized by the agency regarding an accident or unsafe practice, otherwise known as post-incident drug testing, which is what we're going to focus on today, and then, of course, as part of a follow-up to any counseling or rehabilitation program for illegal drug use through employee assistance programs. The reasonable suspicion standard requires an indicia of intoxication, usually shown through a trending of poor job performance, if not acute intoxication at a particular time, erratic behavior, and of course odor of alcohol. Follow-up and rehab are part of the EAP or contractual recovery process. When I say contractual, those of you in collective bargaining states are free to negotiate agreements or provisions in your contracts that allow for employees to avail themselves of resources paid for by the employer to recover from habitual drug use or alcohol use. There's a lot of judgment and let's say prejudice in this regard, especially among law enforcement. You know, we're not supposed to take drugs, we're supposed to follow the law, but consider the scenario of the officer who's injured on duty, either through gunfire or stabbing, not to mention car accidents, where quite innocently become addicted to medications that are prescribed by doctors. It's a fairly common occurrence. Those are typically dealt with in that contractual recovery process, or what's known as last chance agreements, and these are essentially voluntary. An officer is either confesses, comes clean, or is caught in an intoxicated state. The value of the employee is assessed, and the desire to maintain the employee on the job. They enter into these voluntary agreements, and that results in obviously voluntary testing through the follow-up and rehab procedure. But what we want to talk about today are the post-accident testing cases. Post-accident testing really began in 1989, and it began before that, but the Supreme Court case issued its opinion in 1989 in the Skinner v. Railway Labor Executives Association, which was the locomotive drivers, the union at the time. And the court looked at mandatory testing of locomotive engineers by the company as a result of having accidents. And the court, in evaluating this, came up with two things. They came up with the dangerous instrumentality doctrine and the special needs doctrine. And what that basically says is there are some activities that are so inherently dangerous to the public that there's a special need, because of that inherent danger, there's a special need on the part of the employer to ensure that its employees are not engaged in the illegal use of drugs or the inappropriate use of substances that might be legal while working. And the court ruled that where a Fourth Amendment intrusion serves a special need beyond the normal need for law enforcement, it is necessary to balance an individual's privacy expectations against the government's interest to determine whether it is impractical to require a warrant for some level of individualized suspicion in a particular context. What does that mean? Well, first of all, what it means is there's an acknowledgement that drug testing in some way invades your individual right to privacy. But what the court is saying is that your individual right to privacy has to be weighed against the greater right of the public or the need of the employer to ensure the safety of the public, so that if the testing is the least intrusive possible in order to get the most effective results, then the intrusion in the privacy is not considered to be so sufficient that you should not be prevented or prohibited from taking these drug tests. And that's how they basically balance out the needs of the many versus the needs of the rights of the few in order to come up with this special needs doctrine and the invasion of the Fourth Amendment right to privacy. And the screen basically spells out exactly what I was saying. In all of these contexts, what we're talking about really, if you see this in the first bullet area, we're talking about suspicionless testing. We're not talking about the reasonable indicia of intoxication, trending poor job performance. We're talking about an incident has occurred that tells the employer that there's a need to test, even though there's no indication of intoxication. Now, suspicionless testing can be found in job application testing, random testing for some professions, such as law enforcement, and the post-accident or post-incident testing that we're talking about. Public safety, of course, is the balance that is sought in the weighing of the rights versus the need. That is, the individual right to privacy versus the need for public safety. It is this rationale that renders most post-accident testing legal, even where there is no indicia of intoxication or drug use. In other words, suspicionless testing. And the court ruled that there is a reduced expectation of privacy for employees that work in an occupation that has historically been regulated pervasively to ensure safety, a goal dependent in so substantial part on the health and fitness of the covered employees. Pervasively regulated. Essentially what that means is your job is so intensely scrutinized or so inherently dangerous or so inherently intrusive on the public that it is in fact regulated. And we know for a fact that law enforcement is one of those professions. You all have to pass physical fitness standards, post certifications in many states, police officer standards and training. There are laws that particularly apply to police officers with regard to search and seizure, Miranda, et cetera. It is a pervasively regulated occupation. There's no question about that. Now, in post-accident or unsafe practices testing is another way to say it. The court substitutes the fact of an accident caused by an employee for indicia of intoxication or any other basis. In other words, we don't need the suspicion. We don't need any basis. We don't have, it's not part of a random program. The accident itself justifies the suspicionless test. Now, in the National Employees Union versus Yitter case, which is highlighted at the bottom, the court said that an accident, if coupled by reasonable and articulated grounds supporting the conclusion that an employee caused the accident, tends to make the question of on-the-job impairment more likely than not. Now, I'm going to come back to this a couple of times because it's pretty important to, when you're negotiating these things for your contract or you're going to litigate whether or not these tests, that is, file a lawsuit over these tests, you need to consider the standard that's been set in these federal cases about a reasonable articulated ground supporting the conclusion that an employee caused the accident. We're not talking about a police officer who happens to be sitting at a stop sign or a red light and gets hit from behind. Anything other than an indication of intoxication or some other basis would not necessarily lead to the conclusion that a suspicionless test is warranted under that type of accident scenario. Now, there must be a plan. It is not enough simply for an employer to assert that all employees will be tested post-accident, because what that does is that is a blanket intrusion on privacy rights that has no basis or justification. Remember, the justification has to be causation or causing an accident. Now, courts will evaluate whether there is a nexus or a connection. Nexus just means connection between the employer's actions and the historical performance of employees. In other words, is there a trend or history of employees having accidents as a result of being under the influence of substances? In other words, is there a rash of DUI accidents taking place in your department that requires that the department establish a blanket post-accident testing for everybody? That's highly unlikely, obviously, under these circumstances. Government, in the AFGE case that's cited at the bottom, government employees driving vehicles does not per se place the general public at risk of harm. And that's in fact true. Just because you have a fleet of vehicles and government employees driving them does not mean that the neighborhood is suddenly at risk of being run down by police officers driving government vehicles. It's actually an absurd statement. There must be a threshold of personal injury and property damage. That means that more than a minor injury and more than a minimal dollar amount before the court will consider privacy rights to be outweighed. And we'll see how that plays out. Now, let's evaluate this statement. There must be a threshold of personal injury and property damage beyond minor injuries or minimal dollar amounts before privacy interests will be outweighed. And you can see below that numerous courts, all of them federal courts, have said that employees under these circumstances do not per se waive their right to privacy and have to be subjected to testing just because of a minor fender bender. Causation and publication is what we're talking about. Post-accident suspicionless testing is not constitutionally permissible. It must be done pursuant to a published plan when the employee has caused the accident. I keep coming back to this, caused the accident, resulting in death or a threshold amount of personal injury. And when we talk about what is the minimum personal injury that we're talking about, well, of course, the courts are not going to set that kind of standard, but they have said things like most likely requiring immediate medical attention away from the accident scene, or some predetermined minimal amount of property damage. Is it going to be $500, $300, $1,000? And of course, over time, that threshold dollar amount would have to be reevaluated, because what was considered a minimal above a minimal accident 30 years ago, $300 30 years ago was a lot of money. Today, that same accident may cost $1,000. So we have to constantly look at these standards and make sure that we are protecting the Fourth Amendment right of privacy against these intrusions by an appropriate standard. And of course, we keep coming back to this. The employee tested must have caused the accident. We're not talking about the person who gets hit from behind, or someone who runs a red light and hits the officer's car. Now, the cases seem to indicate that minor accidents without injury and minimal property damage cannot be a basis for post-accident suspicionless testing, absent some indicia of intoxication or reasonable suspicion at a minimum. So in other words, you happen to have an accident, you back your patrol car into a light pole, you break the lens on the brake light, supervisor shows up and demands that you drop a urine. That would be outside of the standards that we're talking about. Now, I will caution you, just because I'm here saying this doesn't mean that if you happen to be in that situation tonight that you should refuse to follow that order. Under these circumstances, you follow the order to avoid you being disciplined for insubordination, and then before those test results come back, you have a lawsuit filed for injunctive relief, preventing the testing or the release of any results of the testing based upon the Fourth Amendment invasion of your privacy right. It is never the right idea to refuse to follow an order. Okay, now, we got a question before some of you joined about whether or not police officers should be required to submit to suspicionless drug testing after the discharge of a firearm. I'm actually paraphrasing the question. It was not quite that way. Now, this case, Lynch versus the New York City Police Department, in 2013, New York City Police Department officers were subjected to breathalyzer tests for discharging firearms resulting in death or serious injury. What's important to note here is we're talking about a breathalyzer and death or serious bodily injury. Those will turn out to be the two key points that the court focused on. The stated purpose of the policy, and when I say stated, the New York City Police Department officials who testified in this case said that these were their objectives: to protect the integrity of the New York Police Department, to protect the safety of the public and NYPD officers, to deter alcohol intoxication by officers carrying firearms, and to assure the public that one of the most important and daunting powers of the police, the power to apply deadly force when necessary, is not being abused or used by officers who are under the influence of alcohol. But here's my problem with all of this, because the court accepted all of this without analysis. There was no evidence of a pattern or a pervasive problem, period. There was no question with regard to the integrity of the police department as far as officers getting involved in shootings as a result of being intoxicated. There was no indication that the public was in danger in any way by officers who were intoxicated. And as far as assuring that the deadly force was being used when necessary, there was an extensive investigative arm of the New York City Police Department in place at the time, and still is, that investigated the justification for all uses of force, deadly and otherwise. So to say that this is what the court hung its hat on is to say that this was a disingenuous analysis of what the claimed unproven facts were. Now, obviously, I sound a little bit cynical, and I am. I'm a little bit concerned about any invasion of constitutional rights, especially privacy rights, especially for police officers, especially when the courts seem very flippant and easy to turn those rights on their heads without a basis in fact for what the policy was put into place for. So the court rationalized that the immediate purpose of the policy was found not to be the collection of evidence of criminal activity, even though all shootings were investigated as crimes and the scenes treated as crime scenes. So you see that. We acknowledge that you're investigating these as crimes and calling them crime scenes, but we do also say that there is no immediate purpose to conduct a criminal investigation. That's just an absurdity. That's an absolute inconsistent statement by the court. The immediate purpose of the policy was to protect the integrity of the NYPD and the safety of the public by ensuring that officers were in fact fit for duty at the time the force was used. There is an entire body of case law that says that fitness for duty cannot be challenged by an employer unless there's some indication that the officer is unfit for duty. So to do a backward-looking investigation on an officer that has discharged a firearm resulting in death or serious bodily injury and question whether or not they were fit to do that is an outrage to me. Comparing this to the Skinner case, you're going to see some very stark contrast in how the court came up with these standards. I personally don't buy it. I think this case is a disaster for constitutional rights, especially for those of police officers. The court specifically found relevant that the testing was done in every case, regardless of suspicion, and was mandatory, not discretionary. Why the court found that made it more palatable is beyond belief to me as well. The fact that they are, I suppose they're trying to say is that officers weren't cherry-picked or randomly picked out as a result of being engaged in a critical incident. Perhaps that's their rationale, but I still find this to be laughable in terms of establishing a standard. Now, the court in Skinner deemed that urine and blood sampling was constitutionally permissible. That's the railroad case. Skinner is the railroad locomotive case. The Lynch court made note of the fact that the breathalyzer test is significantly less intrusive since no needle stick or exposure of genitalia in front of witnesses is required, thus making the New York City Police Department policy that much more reasonable. So what they're not even doing here, they're not talking about the balancing test or the invasion of privacy to any great degree with regard to the individual officers. They're saying when we compare this to a completely different set of facts and circumstances, to a completely different profession, and where the court allowed for that profession to be intrusively tested, this test by that standard is a lot more reasonable. And I'm going to explain in a minute why I find that to be absolutely distasteful. And here's why. If a locomotive crashes, something went seriously wrong, because trains are not supposed to crash when an engineer is performing as trained and as required by the parameters of the job. Therefore, when a train does crash, something has seriously gone wrong. And it's most likely something the engineer did wrong. On the other hand, when an officer discharges a firearm in accordance with training and within the confines of the law that dictates the permissible use of deadly force, there is nothing accidental or presumably wrong about that action. The only standard by which officers' use of deadly force is measured is whether or not the force was reasonable based upon the facts and circumstances known to the officer at the time, and whether or not a reasonable police officer faced with the same set of facts and circumstances would have acted the same way. In other words, if we give you a firearm, train you on how to use it, create scenarios in that training that dictate how and when you're supposed to use it in response to a force or a threat of force, then that's the appropriate time to use it, and you do it exactly that way, we now have to determine whether or not you were somehow unfit when you made that decision. It's a rank inconsistency. It makes absolutely no sense, and it's completely inconsistent with the standards that are established in Skinner, in my opinion. The question is, would the highly intrusive blood and urine sampling found legal in the context of the accident in Skinner be permissible in a justifiable use of deadly force scenario? This court seems to suggest that it might be permissible, but they didn't reach the question because they were dealing with something that was far less intrusive. All of the breathalyzer tests in this particular case were done in the private confines of isolated either tent, vehicle, or building, and a high-level officer, executive officer, was responsible for the collection of the testing, a captain and above. And the court found that was sufficient protections of the officer's privacy and dignity to make these tests permissible. Nowhere in case law do I find anything that dictates whether or not the test is done in a dignified and respectable manner, which then makes it okay to invade the right to privacy. In other words, what I'm saying, this Lynch case has turned Fourth Amendment jurisprudence on its head. They've allowed a suspicionless test based upon a completely different standard than what would allow the deadly force to be used to begin with, and have made the invasion of the privacy of the officer far less restrictive than the actual use of the force itself, which to me I find to be absolutely inconsistent with critical incident jurisprudence or law, as well as Fourth Amendment law. But that's where the courts have left us. Now, this has admittedly been a very brief presentation based upon the narrow subject matter that we were discussing, so we will have lots of time for questions. And so, PJ, why don't we open up this floor for questions?
The first question we have is from somebody who was involved in an incident, and I'm going to summarize their question. They're asking, is it prudent for testing for an officer to eliminate any question of impropriety? His department, I'll read it from the beginning, I apologize. He was involved in a lethal use of force incident and asked to be tested following the incident in order to ensure that he had total transparency in the incident. His department did not have him tested, but stated that he could do it on his own. His question is it prudent to ask for testing for an officer to eliminate any question of impropriety, or was he putting himself at risk by asking the department?
I think you're putting yourself at risk in a number of ways. Not necessarily taking a justifiable shooting and making it unjustifiable, but it's imprudent for this reason. You're establishing a precedent and a standard whereby officers who do not opt to be tested will carry around with them a cloud of suspicion that would not otherwise have been created. It is incorrect, in my view, and there are a number of people who share this view, it is incorrect, in my view, to question an officer's fitness to be on duty and to have conducted the actions that were conducted when they were otherwise objectively deemed to be legal, justifiable, and reasonable. To then say that in spite of all of that, under the guise of being transparent, that we're going to submit to this testing because you're waiving a fundamental constitutional right to privacy, number one. You're giving the employer, and for that matter, the general public, access to whatever those results are, because those test results will not necessarily be considered confidential or private, and you're allowing for an intrusive look inside your body that's not otherwise warranted or justifiable, and by the way, answers no question about the shooting itself. It is absolutely irrelevant to the investigation of a justified shooting. If the shooting itself is not justified, that still doesn't justify an intrusion into the Fourth Amendment right to privacy. It may mean you committed some crime, but it does not mean that you were intoxicated when you did it. And on top of that, unless you are very, very careful in the waiver of the privacy right connected to the testing as to whether or not any other health condition that you may have could end up being disclosed that could affect your employment. You could end up disclosing a medical condition that you yourself didn't even know. And that could be any one of a number of things. It could be diabetes. It could be pregnancy. It could be any sort of other disease that you might not even know you have, a sexually transmitted disease, for example. Just about anything can be discovered, especially under a blanket waiver of privacy, and where there are no guidelines that restrict what exactly can be tested for. So I just don't think that you go down that road in an employment context, number one, and you certainly don't do it under the stress or the urgencies that are connected to a critical incident. That's a very long-winded answer, but I'm very passionate about this particular subject, and I don't believe that you ever consciously waive your rights, and that's why we have the whole body of case law that we have that protects public employees to some degree in some cases and to a great degree in other cases on those privacy rights.
The next question we have is, what if a department's collective bargaining agreement states that the employer can conduct drug testing at any time?
Well, first of all, I think that is an illegal, unenforceable provision in the collective bargaining agreement. If I were in that bargaining unit, I would be filing an unfair labor practice action potentially against the person who negotiated the contract, because you may have just blanket waived or attempted to waive all of your rights. I'm not advising that you go off and file unfair labor practice actions willy-nilly, but you certainly should not be voting to ratify a contract that allows for the employer at any time to have you subjected to drug testing, unless there's a state statute that authorizes it, and the constitutionality of that state statute has been challenged and it has been deemed to be valid. I would never, as a union, give a blanket waiver to the employer to do anytime testing to all employees. I just think that's absolutely wrong and ludicrous and wouldn't do it. There must be limitations on these types of invasions.
The next question we have comes back to something you touched on. It's if you hit a deer that ran into the roadway, is that caused by the officer?
Well, we could come up with a million scenarios about whether or not it was caused by the accident. I think the statistics speak for themselves that deer cross the road and results in serious accidents that result in serious property damage and in some cases death and serious bodily injury. Now, does that make it the officer's fault? It's going to depend upon the facts and circumstances. Was the officer speeding? Was the officer driving erratically? Was the officer who knows? I'm not an accident reconstructionist, but you have to ask those questions. Just because an animal, which in some cases they're probably a lot more logical and reasonable than human beings driving cars, but that joke aside, you cannot presume that the animal made an attempt to avoid a speeding car. They tend to jump in front of them sort of haphazardly and randomly, and unless the officer was driving in a reckless or negligent manner, I don't think you can say that that was an accident caused by the officer. And I would think one of the things I would do if I were practicing in that jurisdiction, and that's what they were, the practice they were making, I would pull the statistics of how many accidents happen with animals or deer specifically with drivers just across the broad spectrum of the population to determine what the statistical probability or anomaly is of hitting a deer with a car. And then I would think that would fly very much in the face of whether or not there is causation on the part of the driver. Absent, again, those other things that we talked about, speeding and reckless driving, et cetera, that may have contributed.
The next question that we have is, does an employer have a right to test subsequent to accident or injury to determine workers' comp benefits without suspicion?
I have never heard anything like that. I would have to defer to the to the workers' compensation practitioners in that jurisdiction. I don't believe that absent an indicia of intoxication that a workers' compensation statute could justify the invasion of privacy as a result of an accident that was not caused by the officer. It just sounds sort of screwy to me, but I'm not an expert on workers' compensation, and I'm certainly not an expert on the laws in every state. But I would seriously question whether or not that was a valid justification for a post-incident suspicionless drug test. That just does not sound right to me.
The next question is, under what authority can an officer refuse the substance abuse test in a reasonable suspicion or post-accident scenario? Followed up by, what if the officer knows he is not using illegal drugs?
Under what authority can an officer refuse?
Mm-hmm.
Well, this goes back to what I said at the beginning. It's never a good idea to refuse an order subject to insubordination. However, it is highly unlikely that the results of the test come back before you can get into court and challenge the employer's right to make you submit to the test. The result of that lawsuit would most likely be, and what we would do is file a declaratory and injunctive relief action, potentially, among perhaps any other that we could think of for violating a fundamental constitutional right. Maybe a 1983 action. I'm not the expert in 1983, but you would seek to have the results. First of all, you would seek to have the testing stop, number one. And number two, if the testing has been completed, that the results of the test not be revealed and that the test sample and the results themselves be disposed of before publication. And you would have to make the argument that, number one, did not cause this accident. There was no basis for suspicionless testing. And unless they can establish on the record some indicia of intoxication, slurred speech, odor of alcohol, bloodshot eyes, et cetera, then, and that's going to be a fact-finding hearing for the court. Keep in mind that some of these accidents result in head trauma to the officer, and I have actually successfully, on one occasion, made the argument on the scene itself that the officer was not subject to testing absent an odor of alcoholic beverage or some indication that illegal drug use was underway, because all of the things that they were pointing out, the symptoms that they were pointing out were directly caused potentially by the head injury with the blood coming out of the forehead where his head had hit the post, as opposed to any use of drug use, meaning that there was a reasonable explanation for what the symptoms that were being exhibited. He was exhibiting symptoms of a head injury. He wasn't exhibiting symptoms of intoxication. And we didn't have to fight it out in court, but they eventually backed down and they said, yeah, okay. But when you get right down to it, just because there's been an accident does not allow for the invasion of the Fourth Amendment right to privacy on a suspicionless test. There has to be those other, there either has to be that indicia of intoxication or there has to be causation, according to the cases that we've looked at. Again, your jurisdiction may have a different standard, but that's where I would begin.
This next question is a little bit more interesting. If a If post-incident, the officer reveals to me, his attorney, that he will test positive for some substance, what guidance do I give?
We're talking about a very, very difficult situation. If the test is mandated and there is a legal basis for the test, I think that what I would have to do under those circumstances is I would have to have a very serious conversation with my client. Now, we're going to talk completely hypothetically here. If I'm the lawyer representing the officer, I have to tell that person that in all likelihood they will be facing some disciplinary action depending upon what it is. It could be marijuana, could be something more significant, could be steroids, whatever it might be. And the officer has to make a choice, basically, at that point. And here's what some of those choices are, and none of them are very good. One is to disclose in advance of the test and seek some sort of amnesty for being upfront and honest about it. And that would include throwing yourself into a rehab program and acknowledging that you might not be fit for duty until you complete that program. The second option is to let it ride and see if it turns up to be positive. And then the third option, I think, is challenge the legal basis for the test after submission, or if you can get it done fast enough, file the paperwork for the injunctive relief before the test is even administered, and try and challenge the legal basis for the test. But I think, as lawyers, for those lawyers that are on the phone, I think it's incumbent upon us to lay out the various options for the client and allow them to choose which way they want to go, other than lying, because we can't counsel untruthfulness or dishonesty. For those union reps that are out there, those are sort of the same options that you would have to present. But if I were a union rep in that scenario, I would basically say, okay, don't say another word to me. We're going to get the lawyers involved in this, and I'm out of it. So I hope that helps. But it's not a good situation to be in, and there's really, at some point you may end up post-test challenging the results of the test for a variety of reasons. I've been associated with 3 or 4 different positive drug testing cases where we successfully showed that in one case it was an inadvertent ingestion, which we were able to prove, and in 2 other cases we were able to show, one, the laboratory did not follow the proper procedures and the sample was tainted, and then in one we were able to show that there were external influences on the sample. And this was news to me. The female officer who was tested had been to the hair salon within 3 days and had hair color, and the hair color process that they use actually has the tendency to show up in certain types of drug testing as the illegal substance that was revealed. And we had expert testimony to say that that was in fact what happened. And it was no small miracle that this officer, after 30 years, had never had any disciplinary issues and was a star employee. So this was clearly not within her character to have used heroin, is what it showed up as. And nobody who ever worked with her could say that she had indicated the type of erratic behavior that someone who took heroin would be exhibiting. So we had all that going for us. But that's about all I can say on that. And I know none of those options seem very good, but your client sometimes puts you in the position to have to be fighting uphill and backwards. And I will say this, I've said this at a number of my seminars, everybody has the God-given right to sink their own ship, and some will exercise that right.
The next question we have is kind of a play off one of the earlier ones. It's, while I understand the answer to an earlier question, what if an officer at risk for an accident or excessive force claim made private arrangements at the first opportunity to have his blood or urine tested without creating an issue for other officers? This might produce evidence that could be useful in the officer's defense at a later time.
Look, if you want to go out there and create that, let me answer a different way. Nothing stops you from going and having yourself tested. if that's what you want to do. If you are being questioned, or there's some suspicion that you are using illegal drugs or alcohol on duty, and that's what led to your accident or your incident, if there is some indicia of intoxication, then they have the right to test you. If you want to go out and have your own test done because someone is raising the possibility, look, here's the way I view this. They have to prove it, and the only way they can prove it is by ordering you to take the test. If that order is unlawful, it can be challenged. I see no reason to go out and create evidence to respond to innuendo, rumor, or suspicion when it's not the basis for a charge. I just don't see the need to go through the expense to do it, or to put anybody, yourself or anyone who comes after you, to be in that trick bag where, oh, well, we're just going to test everybody. You know, I don't know that would necessarily create that, but if you know you didn't take anything, why do you need a private test to prove it? The question about whether it would be even admissible in the future because of the way it was conducted and who has possession of it, you know, your own doctor obviously could come in and give some sort of testimony, I suppose, but you know, it's creating such a broad hypothetical that I'm just finding difficulty coming up with a rational basis for doing that.
We have a question. Can these test results be protected under Garrity?
No. Garrity only protects testimonial evidence. That is, anytime you say or write a statement is what Garrity protects. If you are ordered to submit to a drug test, there is no immunity for the use of that test in any subsequent criminal proceeding. In fact, the Lynch case even acknowledged that there may be criminal proceedings that result from these tests, but because that's not the department's objective, we're not going to consider that. That's a paraphrasing of what the court said. So the fact is that if you ordered, you do not have the immunity protections as you would if you were ordered to give a statement, which is why if there's some basis upon which to challenge the test itself or the order to submit to the test, the validity of that, then that's the way you should proceed. Because once those results are out, they're out, and that bell is rung.
We have I'm going to ask two questions because they relate to each other. The first one is, can you ask to consult an attorney before testing? And the second one is, in the event of a lethal force incident, should I try to postpone any testing until my FOP rep has responded to the location?
Repeat the first part of the question, because I was focused on the FOP rep part.
The first one is ask to consult an attorney before testing, and the second one...
Okay. There is no Miranda-type right with regard to testing that I'm aware of. I see no harm in asking to consult with an attorney before you submit to the test. That certainly would be something I would do. Whether or not the FOP rep is present, I'm not sure that there's any effect. See, the Weingarten right is basically you're entitled to union representation if you're going to be asked questions that you believe if you answer honestly will result in discipline. So I don't know if there's a qualifying right for anything else, but it may, for those of you in collective bargaining states, it may be something well worth putting into your collective bargaining agreements under these drug testing scenarios. But I'm sure I would ask that. I want to talk to my attorney before I submit to the test. I mean, you're certainly free to ask that question. Now, do they have to allow you access to an attorney before you provide a urine sample? I'm not sure they do. I'm not sure they do. I think they could probably say, no, we're ordering you to provide the sample now, and if you don't, it's insubordination. Okay, then under those circumstances, you submit to the test, and you challenge the validity of the order and the requirement that you submit to the test after the fact.
Our next question is, what happens if the test results come back before relief can be filed in a court? My agency's testing has come back anywhere from a few hours to 3 days.
I'm not sure you have a valid result that comes back in a few hours. I mean, there are some preliminary tests they can do with various chemical reactions and so forth, but I don't believe that those are test results that would be admissible because they're preliminary. They don't. In other words, those tests don't necessarily measure the nanograms or nanoliters per liter of or volume of blood or urine that's tested. But this is something. If this is enough of a concern, then one of the strategies you can employ is have your the next time something like this comes up, you can file the lawsuit, and even though the drug test results are in, they can be suppressed, number one, and no action taken on them, potentially. I did say once the bell is rung, it's rung, but that does not necessarily mean that you don't have a remedy. And the way it's pled is, that is the way you argue to the court, is that this is a violation of the Fourth Amendment, and although this violation has already occurred, it is subject to repetition, and therefore it is not moot, where we should flesh out whether or not this is a violation of the officer's rights under these circumstances, and the lawsuit would continue. It is possible in some instances for a judge to issue an order holding the results and any disciplinary action in abeyance pending the outcome of the litigation of the merits of the case. But it's a tough call, but it's one I think your lawyers need to be prepared at a moment's notice to file this paperwork and get an emergency order issued, which can be done in a couple hours if it's done at the right time.
We have another two-parter or related questions. The first one is it the responsibility of the officer or employee to obtain the alcohol drug results? If employer obtain information of other medical conditions, do they violate Hipaa? And then the second one is, can an officer be ordered to sign a Hipaa release for medical records?
Okay. Going back to the beginning, is it the officer's responsibility? I don't think it's your responsibility, but I think it's your right. Any document that's going to be used in any personnel action against you is your right to have a copy of it. So I think you should make it your responsibility to get copies of everything. Drug and alcohol test results are not necessarily documents that are used in the diagnosis and treatment of any medical condition, so it is not likely that HIPAA applies, or for that matter, the ADA privacy provisions, and because these tests are being conducted in order to disclose whether or not there is an alcohol or if there's alcohol or other substance in the blood. The question comes in, if you sign a waiver that's a blanket waiver for any and all results, does that allow for the lab to provide all of those results to the employer? And the answer there would be yes. So HIPAA is not implicated with regard to the laboratory or to any physician that conducts the test, but ADA privacy rights may subject the department to certain standards and requirements, such as an HR medical records official takes possession of any and all information that's revealed from these tests that's not related to substance abuse or alcohol abuse, which has to be then forwarded on to the appropriate disciplinary or investigative authorities. So it's sort of a split. I think most of what they find in that sample that's not related to illegal substance use would in fact be protected, and the ADA requires that that information be withheld even from immediate supervisors and restricted to only those folks in the agency that have an operational need to know, which is why they have designated in the law, require you to designate the medical records professional.
An addendum to that, there was a clarification written in. As far as HIPAA in terms of emergency room treatment post-accident that includes regular tests. So I believe they're going for, can they get you to sign a waiver to release your ER treatment records after an incident to try and catch you without doing the test? Does that make sense?
Can they order you to sign a waiver of your medical records? Well, here, let's again go back. If there's an indicia of intoxication, the law allows the police, under certain circumstances, to have an accident victim tested in the emergency room. Okay, that's just about every state's DUI laws have those provisions. So if there's some indicia of intoxication, even unconscious, there's an overwhelming odor of alcohol, then that's possible. Now, if it's an accident that was not caused by the officer, that's resulted in some personal injury other than the officer, not other than the officer, it's just the officer who's injured in this accident, do they have the right to force you to sign a waiver to that? I don't think so. I really don't. I don't think they have the ability to access that information. Now, here's the good news. If they order you to sign that waiver, upon penalty of being terminated if you don't, then the waiver is not voluntary and it's subject to being challenged. Any information that's obtained as a result of that illegal order cannot be used against you if a judge deems that it was an illegal search and seizure. On top of which, the waiver itself not being voluntary flies in the face of whether or not this is a willing or consensual disclosure of what is otherwise protected and privileged information. So again, it depends upon what the nature of the accident is, what the indicia is, and whether or not there's any right to issue the order to begin with. So that order would have to be challenged at some point. Now, a question that has not been asked that sort of stems from this is, do you get your job back if you're terminated for insubordination for violating what ultimately turns out to be an illegal order? In most cases, I would suggest that the answer to that would be yes, but I would be very careful if I'm in a non-labor state where there is no collective bargaining and the Civil Service Commission is not necessarily that strong. You may end up having to file civil suits to get your job back, which can end up in a very long road. That's not to say that you should willy-nilly just agree to any order that's being given, but you should, your unit, your lodge, your agency officers should get together and seek legal counsel, and if these policies exist and this practice exists, they should be challenged, absolutely be challenged.
What if an officer accused by a complainant of using drugs or alcohol on duty, but absent from any other indicia, receives a suggestion from a supervisor that he should voluntarily submit to a drug test to clear the air? I would think this is a problem in that the suggestion came from a supervisor and therefore the officer might have felt compelled to submit.
Well, a suggestion is not an order, number one, and they cannot, listen, absent any indicia, you know, some anonymous tips have to be corroborated. Complaints by people who result in a suggestion that you do something to clear the air, in my mind, should be responded to, there is no air to clear. Okay? I am not submitting to a drug test because it's an offensive question to begin with. I don't use drugs. I'm not submitting to a test unless you order me to, and if you order me to, I'm going to talk to my attorney. That is just absolute absurdity. You know, these supervisors can suggest whatever they want. Until they issue an order, you're not compelled to do anything, and if they issue an illegal order, you should challenge it.
Another question is, if you are ordered to submit to having a sample taken for testing, does it make a difference what type of sample you might offer to comply? Would blood be potentially more accurate than breath or urine? Wouldn't testing a hair sample subject you to liability for a substance that might have been used long before the incident?
I'm not an expert on what these various tests reveal. I'm not a chemist. I do agree that a hair test, from what I've been told, will reveal things that could have been 7, 8, 9, 10 years prior, and who knows how it got into your system. I would never offer any type of test that I volunteer for. They have, let them order you, and then you challenge whether or not there's a reasonable basis under the law for them to ask you to take that test. The least intrusive means will have the least difficulty getting through a judicial review of the type of test that's being done. So if it's a urine test, that's probably on the low end, or a breathalyzer test, it's probably on the low end of intrusiveness. When you start talking about needle sticks and cutting hair, now you're talking about tests that are more intrusive. My suggestion is, if there is no legal basis for them to ask you to submit to the test and ask you to choose which one you want to illegally do, don't do any of them, and challenge their authority to order you to take the test. Whatever your drug testing program is in your agency, because officers are legally subjected to random drug and urinalysis tests, whether they blood, urine, whatever it is, make sure that the type of testing they're doing is legally authorized and that all testing is done in compliance with state and federal statutes and laws. And the only way to do that is have an expert review the policies and the practices of the department to determine that it's being done correctly.
Here's one. How standard is it for departments to request blood or urine after every OIS, and for the investigating agencies to say that if it is not given voluntarily, a search warrant will be obtained for the blood?
Well, my attitude is, if you're threatening me with a warrant, if I don't do something voluntarily, go get your warrant. That's number one. How standard is it? I don't know. I don't know that there's a rash of post-critical incident drug testing taking place. I know that every seminar I've been in, there are some departments where, or some of those groups where at least one department in the group is subject to that type of testing, and my advice is always to challenge any blanket testing policy through your attorneys. Absolutely. And if they're telling you we'll go get a warrant, that means that they know they don't have a right to have it, in my opinion. So we've been at it for about an hour, so let's have just 2 more questions, and then the rest of the questions we can be submitted.
Okay. The next question is under Garrity. Why would the blood or breath draw under an employee's order be any different than a statement?
Because that's what the law says.
Okay.
The Supreme Court, well, the courts have said, not the Supreme Court, but the courts have said it's testimonial only. Garrity only protects you for the statements that you make, not anything else. Let's do 2 more. That was an easy one.
Well, we only have 1 more, and this is a rehash of one that we answered, or we addressed above.
Okay, someone didn't like the answer.
Well, no, it's from the actual seminar. Is there a standard or minimum dollar amount of damage or personal injury to make testing permissible?
No, as I said, there is no standard. The courts are going to determine whether something is minimal or something more than minimal. What the term the courts use is de minimis. And it's really going to depend upon how material the accident is. Now, some courts may say $300 is enough. Other courts may say $1,000 is not enough. It just all depends upon the jurisdiction and how the courts handle it. But there is no standard dollar amount that is discussed. It has to be more than minor.
And that exhausts our questions.
Thank you, everybody, for tuning in and attending. I hope this has been helpful for you. We will continue to take questions over the coming days as you get a chance to think about this and as you settle into it. Let us know if you have any other questions. PJ, I'm having trouble getting I guess this is the last screen. But you can submit your questions to an email address that PJ is going to give you right now.
It is labor@fop.net. Fairly straightforward. We'll also post that in the article on fop.net. If you go to it, there'll be the address there that you can send questions to.
And where will this webinar be posted?
It'll be on the front page under news events, and you'll see at the title, the drug testing title.
Okay. Having said all that, thank you all again for attending. It's always our pleasure to produce these webinars and to provide as much information as possible to make your lives and your jobs easier. You are doing great work out there. We all appreciate it, and you are our heroes. So keep up the good work, stay safe, and let us know if there's anything we can do for you if you have any questions. Thank you, PJ.
Thank you, Mike.